Good morning to you. Good morning. Good morning. My name is Lawyer Tokunbo. For all those that have been eager to see me or to know me or to match my name with my face, um, I am not new on social media. I am a social media lawyer. So I am an influence social media lawyer, an influence social media lawyer, which basically means that I come to educate people on UK law, most especially on immigration and nationality law. I advise people from time to time, put them on notice as to what to do when coming into the United Kingdom, or what to expect when coming into the United Kingdom, or when staying in the UK, the right visa to apply for to come to UK. Yesterday we had a stringent court hearing in the office via CVP link. We had a CVP link court hearing whereby everyone was present at the hearing, including the appellant and the sponsors. The Home Office agent was also there. Somebody somehow representing the Home Office, which is the Secretary of State for the Home Department. The judge was also there, and I was there as the lawyer representing the appellant. We commenced case at 2 o'clock yesterday, about 2:04, 2:03 we commenced thereabouts, and we finished at 4:05. We finished at 4:05 yesterday, which basically means that it takes us more than 2 hours to complete. We had to iron some issues, technical issues, before we can commence the full hearing. We look at the technicalities of the case, especially given the fact that there is so much going on with regards to the EU withdrawal agreement. A lot of things has happened in the past 1 year, since December 2020, that the United Kingdom government signed off from the membership. Because of that, uh, new rules have emerged. It has emerged in a way that the appeal rights given to family members are very tedious, and if you are a practitioner like me and you are not on top of your game, you are going to fall foul. You are going to mess up your client case, and you are going to mess up your dignity and credibility at the same time. A little bit hidden, some of the new appeal right, the grounds for the appeal rights, they are hidden in a way that it needs someone with a good detailed eye to see and to pinpoint and bring out the points that needed to work on in favor of your clients. Yesterday, what is most important yesterday is that we were able to iron the technicalities of the Home Office reason for refusal. And at the end of the day, we note that the person who actually refused the application is not aware, or not fully fledged, or not conversant with the rules in the new law, and does not even understand the type of stamps that's supposed to be inside the passport of the applicant traveling into the United Kingdom. What I noticed yesterday is that the United Kingdom government shot itself at the back of the leg. It shot itself at the back of the leg in a way that when drafting the withdrawal agreement, some of the things that were incorporated basically still means that the rights are still pretty much standing. But for you to understand the withdrawal agreement, you have to be one of me that can read at any time, that can listen to authorities, that can follow procedures, and that understand the immigration laws very well. If you don't understand the immigration laws very well, you might somehow struggle yesterday in the um, in the hearing. I mean, the representatives brought by the Secretary of State yesterday is a qualified lawyer because he's a barrister. He is a qualified lawyer. He is a barrister because he's a counsel. But what I noticed about him yesterday is that he did not do a good readings. He didn't have a good readings yesterday about what to say in terms of, although representing government in the Home Office case, it's just a matter of reading or listening to your superior and come and just blow out the grammar that you have in your mouth. But in private practice, we don't eat accent, we don't eat grammar. We eat good explanations of English on immigration laws, good understanding of immigration law, good presentation on immigration law. That is what we eat in practice. If you can see, there are many people practicing immigration law. Although some could be a OIC advisor, but I am a supreme solicitor. So which means that I have 2 certificates as a supreme solicitor and as a senior immigration legally qualified person. So I can decide to take and use any of them at any time because I have insurance covering me as a practitioner at all time. Moving forward smoothly in the matter of yesterday, it is very important for appellant and the sponsor to know each other very well and to communicate effectively as to what to put forward in terms of their defense. Now, there is nothing under the old rules in 2016 regulations that basically says that you must have a visa as a family member to rely on your EA person in the UK. There is nothing under the law to say that you must have a particular stamps to use in the UK. As long as there is evidence that you are a family member and you are depending on your EA person and there is evidence and element of dependency, the application mustn't struggle at all. I stand to be corrected. There is nothing under the 2016 regulations that basically says that you must by all means have a stamp to cover you to enter United Kingdom. There is nothing that basically asks you to do that. And if there is nothing asking you to do that, I am thinking whichever side the Home Office wants to rely on in the agreement, in the withdrawal agreement, the 2016 regulations, despite the fact that the Home Office is punching bags on Appendix 14, Appendix 11 of the EU law, of the new law, the punching bag will still be punching it towards 2016 regulations, most especially when the client, which means the appellant, had entered the United Kingdom before 31st of December and submitted application before 31st of December. It basically means that the right will be there, but most mistakes that a lot of them did is because they applied by themselves without taking legal advice. The client that I represent yesterday did not take legal advice. It was over sabi to know. You see, in life, what you don't know, you have to ask questions. When you ask questions on things that you don't understand, you will be educated. You will have education, you will be educated on it, you will be given a vital information that will assist you in that aspect. And so, when making that application last year on the new scheme, he was supposed to apply for residence card first. Yes, he was supposed to apply on a paper for a residence card, at the same time applying that one. If he were to apply for residence card, which means on the paperwork, on the manual paper, without using the new scheme straight away, he would have something much better. When he was refused, it would have been difficult to refuse. And not only that, when he was refused, there was no DNA to corroborate the claim that they are related. There was no DNA. They are siblings, brother and sisters, but there wasn't a DNA to support that argument. If it were to be British birth certificate, it would have been sufficient to say, or European or US birth certificate, it would have been easy to accept it, because the counterpart would easily check with the other one and say, can you check your record? Was this certificate issued by the authority of the United States Home Department? Was it issued by the German Department, authority of the German Home Department? They will have checked easily. But we have situations that is so complex and difficult to get assistance from developing world, from Africans, So when it comes to African submission or India submission, Pakistan submission, there has to be a DNA. There has to be a DNA to assist, to assist your claim. If there isn't a DNA to assist your claim, the application will suffer in that aspect. So I understand from that angle, and it's a lesson in future. When submitting an application, try as much as possible get legal advice on immigration matters. If you know, you know it. If you don't know, you don't know it. It is a complex area of law because it changes from time to time. It is different from any other law, family law, county court judgment law, all those small criminal law cases. Immigration law is different. Immigration law changes all the time. Criminal law code does not change. It remains stagnant. It stays there. It's very old. It has been coming long time. Family law, Matrimonial Causes Act 1973 has been long dated back. But in terms of the United Kingdom immigration law, the Nationality Act, which is the 1971 oldest act, has embedded so many things underneath. It has gotten so many things that have used in terms of exactions, updating laws all the time, paperwork, taking one out, putting the other one in. Most especially on the EU withdrawal agreement, on Brexit, it's very complex, and you need to take advice. If you are a family member of a European person, you need to take advice. Your right has not ended on the 31st of December 2020. Your right as a family member hasn't ended. Some families still have some rights, and those rights cannot be taken away from them because there is an agreement between the two nations. The United Kingdom authorities signed agreement with Luxembourg. They signed agreement with Luxembourg, meaning that the headquarters of the European country members, where the president signed and the UK government also signed, and they agreed, to protect the right of the UK citizens while they are in European continent, and also sign agreement to protect the European citizens while they are in the United Kingdom. So the agreement is like a section 25A in Matrimonial Causes Act, which means that there is no claim break where there is a child between man and woman that is divorcing their marriage. The moment there is a child in that relationship, there is no claim break. And exactly what happened in this situation, there is no claim break between the United Kingdom government and Luxembourg. So that is the situation as we speak. So the argument yesterday was finest. It was standard, it was complex, it was efficient, and it was, consistent, because the consistency of it came by way of assisting the judge sitting yesterday, because the judge himself was saying, I have not familiar myself with the withdrawal agreement, with the EU appendix, this appendix, that. And I said to the judge that I will assist you. I will assist you. And I did assisted him to some extent in my submission yesterday, just to make sure that I got something for my client, which is the appellant, yesterday. So as it is, we spent 2 hours. We put in things. I cannot tell you more than that because of the sensitivity of the case. I can only brief you on what happens and the grounds and the agreements and presentation. That was the first case of its type in this office. Yesterday's case was the first of its type, but I have more than 15 of it that is going through appeal. But I think they will be getting spaces for yet next year. But I have almost 15 of them that came from outside to ask me to assist them. They submitted the application on their own. But I can tell you vividly, I have almost 15 or more that I am assisting on the appeal right in the United Kingdom. So ladies and gentlemen, my name has not changed, Lawyer Tokunbo Olagbaye. I'm on 0208 309 8808. 0208 309 8808. A lot of people are saying that they cannot get through to me. That is why I have staffs in the office. So you can call to the staff directly. If you are using the office mobile WhatsApp, 07908 628240. You can also check me on Facebook, where I have over 67,000 followers. You know, I have over 67,000 on Facebook. So you can check and follow me on Facebook. And if you are not a Facebook person, please stay here. I will be giving you more than Facebook, because I lately find this very relaxed and interesting to stay. So that is the issue on the feedback of on the appeal that we had in my office yesterday remotely. I have to go off now because I want to interview staffs in Lagos. I want to interview staffs in Lagos on a new project that is taking place there. So I want to interview staffs, and we've got about 50 people on ground that came for the interview. We will be interviewing 50 of them today, and I will be taking 11 or 12 out of them. I will be giving 11 or 12 of them jobs in Nigeria today. So, which means, well, I have to unite with them now on the video link to do the interview on a different project entirely. It is not on law. So until next time, I remain your humble lawyer, Tokunbo Olagbaye. Thank you so much. The numbers are 0208 309 8808. 0208 309 8808, and then the WhatsApp number is 07908 628240. 07908 628240. I will be coming on YouTube from time to time, more than Facebook, to assist YouTube viewers more. So please subscribe and follow me on this YouTube. Tell your family member to subscribe and follow me on. Until next time, bye for now.